Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Megan Neal presenting for us. If you are unfamiliar with the format of this event, first, Megan is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Megan will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Megan to get us started.
All right. Hey, everyone. Thanks, Marissa. As Marissa said, I'm Megan. I work in Legal Aid's Greensboro office. I do benefits cases, especially SSI and SSDI cases. And today I wanted to talk to you all a little bit about ALJ hearings in disability benefits cases. So those are hearings for both SSI and SSDI. So those are two different programs and they have some different eligibility requirements, but the medical definition of disability is the same for those two programs. And that's mostly what is talked about in a hearing. So it's going to be, we're using the same medical standard for both SSDI cases and SSI cases, and that's what your hearing is going to be about. And also we're talking specifically about adult cases. Kids cases are going to be a little bit different. So we're talking about the adult standard of disability. So with all that said, let's get started. So I was just talking about the medical definition of disability being the same for both SSI and SSDI cases. So you might be wondering what that is. What does that mean? The way I would sum that up just briefly is that you have to have a severe disability that prevents you from doing any type of work on a continuous, consistent, and full-time basis. The way that plays out is pretty complicated, pretty complex, but we can kind of just use that definition of disability for this presentation. I went over in more detail the medical definition of disability in a prior presentation, so you can look that up on our Facebook page if you want to check that out and go into that in a little more depth. But this on this slide here, I have the definition of disability for adults from the regulations. I'll just read that for you. The regulations define disability as the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. So that's what you're trying to prove in your disability hearing. We're going to first talk a little bit about the appeals process, and we're going to look at this chart on the slide in a little bit more depth. This is a chart that just goes through the different levels of appeal for an SSDI, SSI application. And this chart is using fiscal year 2024 data because that's, I think, the most up-to-date data that we have out there. This chart, I believe, was made by the Social Security Administration. So we start off at the initial level. That's your initial application. As you can see, hopefully you can see in this slide. The majority, unfortunately, majority of cases get denied at the initial level. That's 62% of cases are denied at the initial level. And 38% are approved. So I think the important theme of this chart is that you want to keep appealing until you get at least to the administrative law judge level of appeal, because at least statistically speaking, your chances of winning are higher at highest at that level. And I should note also these are statistics for all states. This is not just North Carolina specific, so it might vary a little bit depending on the state and other things going on in the locality where you are. But so if you get a disapproved claim at the initial level and you want to appeal it, your next level of appeal is called a reconsideration. You're going to make a request for reconsideration. Unfortunately, at this level, only 16% of cases are approved and 84% are denied. At this level, the reconsideration level, the case is sent back to the Disability Determination Services, DDS, which is basically the office that reviews the medical evidence and medical claims. In North Carolina, that office is in Raleigh. At the DDS, when the case gets sent to the DDS at the reconsideration level, they're going to have a different group of people reviewing your case than who reviewed it the first time around at the initial level. So if you're one of the 84% of people whose cases are denied at the reconsideration level, the next level of appeal is the ALJ hearing level, administrative law judge. When you have an ALJ hearing, that's when you're going to appear either by in person or on the phone or online video hearing, or what they call agency video. You're going to appear before an administrative law judge. This is going to be your chance to make your case before a judge. The judge is going to review all your medical records and any other evidence you wish to provide. If you have a representative, that representative can appear with you. There might be a vocational expert at your hearing or even a medical expert. We're going to talk about this a little bit more later on, but you do have the best chance of winning at this level. 51% of cases are allowed at this level. 33% are denied, 16% are dismissed. That's when you don't show up to your hearing when it's scheduled for. It will just get dismissed. But if your case is denied at that level, you have the chance to appeal it to the Appeals Council. This is a final level of appeal, the final level of administrative appeal in this process. This is going to be a panel of 3 administrative law judges. They are located in Falls Church, Virginia. They're going to be making a decision on your case just on the paper. So this is what we call paper appeal. You're not going to appear in person. You're going to write a letter, or your representative is going to write a letter to the Appeals Council explaining what errors you think the administrative law judge made in your hearing decision. The statistics at the Appeals Council are very, very dismal. Only 1% of cases are allowed at this level. 3% are dismissed. 16% are remanded and 80% are denied, we consider a remand a win at the appeals council, because what that means is the appeals council believes that the ALJ made some errors and they're actually going to send your case back to usually the original administrative law judge that heard your case, and ask the judge to have a new hearing and correct those errors. Finally, if your case is denied at the appeals council level, you can appeal to federal court. In federal court, 1% of cases are allowed, 4% are dismissed. 63% are remanded. Again, we consider that a win because it's sent back to the administrative law judge who heard your case to correct some errors. 32% are denied at federal court. So this is just so you can kind of get a sense of the overall process, and what you might be expecting as you go through appeals for your case. So let's talk about probably the most important thing, appeals deadlines. The most important thing you're going to do in your case is check your mail and read the notices that you get from Social Security. The notices are always going to tell you the appeals deadlines. You're going to want to go through more than just the first page of the notice. For medical eligibility cases, you have 60 days to appeal a decision plus 5 days for mailing. So what that really means is you have 65 days from the date on the notice to make your appeal. I always suggest people not use those 5 days. Just think of it as 60 days, but technically it's 65 days. If you're late filing your appeal, there is an exception to the 65-day limit if you have good cause. So good cause means a really good reason. So that's going to be something like you were hospitalized for an extended period of time and you missed your deadline. You would want to write a letter explaining why you missed your deadline. In order to make your appeal, you can do it on SSA's website. You can go to ssa.gov. When you make that appeal, you're going to want to make sure that you always keep proof of the fact that you submitted an appeal, because just in case Social Security loses something or says they don't have what you submitted, you want to have your own proof that you submitted it and that you submitted it in time. So if you're doing it on a website, you're going to want to print, if you're doing it on the website, the Social Security website, you're going to want to print or save the screen that pops up right after you submit it. And it's going to show the date and time that you submitted it. Another way you can file an appeal is by going to your local Social Security office and completing the appeal form. When you go there, when you submit it, again, you're going to want to make sure you keep your proof that you submitted it on time. So you're going to want to get Social Security to date stamp whatever form you're submitting to them, and then you keep your own copy. I'm going to talk now about preparing for your administrative law judge hearing. So again, the administrative law judge hearing is going to come after you've submitted your initial application. It was denied. You've submitted a request for reconsideration. That was denied. Then you appeal that within 65 days of the date on the reconsideration decision. And then eventually your administrative law judge hearing is going to get scheduled. Uh, Often the first question someone might ask is, should I get an attorney? So that's totally, of course, it's your choice if you're able to get an attorney. Our opinion is generally you're going to be better off with an attorney representing you. But, that being said, lots of people do represent themselves, and you can represent yourself at an ALJ hearing. There are lots of private attorneys who take these cases. They get paid on a contingency basis. So what that means is they're getting paid from your retroactive Social Security benefits if your case is approved. So they can take up to 25% of your retroactive benefit, and it's capped at $9,200. Our office, Legal Aid of North Carolina, of course, we don't take a fee. So if you live in North Carolina and you can't find someone from the private bar to represent you, if you've been turned down by two private attorneys, you can call our office. If you meet our income and other eligibility requirements, and if the local legal aid office to you has the available resources at the time, we can take a look at your case to see if we'd be able to represent you. Again, if you can't find an attorney to help you, you can represent yourself. Many people do. But if you're representing yourself, remember, like we looked at earlier, this is your best chance to get approved, statistically speaking, at least. So you want to make sure that you really take preparation for your hearing seriously and make sure you prepare ahead of time. What does it look like to prepare? So you want to make sure that you are gathering all of your medical evidence and submitting it to the administrative law judge at least 5 business days before the hearing. And medical evidence, of course, is primarily, it's going to be medical records. What you can do is you can get a copy of your hearing file from the hearing office and you can review that. So you're going to want to see what they have already. They should have been making requests for your medical records. You want to make sure that the file is complete, that they have all of your medical records for the relevant period of time. And you're going to want to notify the hearing office as soon as you notice if anything is missing. And the hearing office should be able to help you make requests for those missing records. One thing you can do is, if you can try to get a medical opinion from your treating doctor, one of your treating doctors or specialists. You can ask them to write a letter about your limitations and ask them to explain why they think you aren't able to work. You also have a right to submit third-party medical evidence or any other evidence you think might be helpful. So you could try to get a third-party witness statement regarding that person's firsthand observations of your limitations. So that's going to be someone like a close family friend or a family member or even an employer or a former employer or even coworker. Hearings happen at the Office of Hearings Operations. You will be given 75 days notice for when your hearing is going to be scheduled. And there are 4 different ways that you can appear at the hearing. So you can appear in person, you can appear by agency video. So that's when you go to a Social Security office in person, and they set up a like video screen situation, and you can see the judge um, on video. Also, they have online video hearings, so that's going to be like that's going to be on Microsoft Teams, which is just like Zoom. And the final way is you can have a hearing by audio, so that's on the telephone. Um, so those are your four different ways. Once you request a hearing, you're going to get a letter back from the hearing office pretty soon, and they're going to give you the option of, they're going to give you these different options, and they're going to ask you to fill out a form or two about which ways you object to having your hearing held. Um, and then you're going to have to fill out that form and send it back to them. I want to talk briefly about what we call the five-step sequential evaluation process. And that's because these are the questions that the judge is trying to answer when you're having your hearing. These are the questions that the judge is going to be answering in your hearing decision. So I think it's important for you to know what are the key points that the judge is looking at. I did go over this in more depth in one of my prior presentations, so you can check that out on our Facebook page. But just to quickly recap, these are the five questions that make up the disability determination process. So the first question, sorry, these are sequential. So that means they go one after the other. Okay, so the first question is the claimant engaging in substantial gainful activity? So what that means is, are you currently working? And if so, are your earnings above the income threshold that the government calls SGA, substantial gainful activity? And in 2025, for non-blind individuals, that's $1,620 a month. For blind individuals, it's $2,700 a month. That number changes every year. So if you're watching this, not in 2025, you can go to the SSA.gov website and it will be on there. If the answer to this question is yes, you are working and you're earning above SGA, then the Social Security Administration is going to find that you are not disabled. You will not win your case if you are earning above that level. If the answer is no, you're not working, or maybe you are working, but you're earning less than this, you can move on to the next step in the process. And that's step two. Does the claimant have a severe impairment or combination of impairments that meets the duration requirement? So in this step, what they're trying to do is make sure that you have a medical diagnosis from an acceptable medical source. So that's like a doctor or a psychologist, someone like that, that at least minimally affects your ability to engage in work-related activities. And this medical condition must have lasted or be expected to last 12 months or to result in death, unfortunately. If yes, you do have a severe impairment, then you can move on to the next step in the process. So the next step, step three, is does the claimant meet or equal one of the Social Security Administration listings? So the SSA has published listings of all these different medical conditions with very specific criteria. attached to them. And so if you meet one of those, Social Security is going to find that you meet the medical definition of disability at this step. You can also find these online. If you don't meet one of these medical conditions with this really specific criteria, and they are hard to meet because they are very severe and have very specific criteria, it's okay because you can just move on to the next step. There are other ways that you can be found disabled. So in order to move on to the next step, the first thing that has to happen is the judge is going to have to determine your RFC, your residual functional capacity. And what that means is what is the most that you can do based on all of your different physical and mental impairments. Once the judge has decided that, then you're going to move on to the next step, step 4, and that's the step at which Social Security is going to look at your past relevant work. So they're going to look at all of the work you've done over the last 5 years, and they're going to compare the work, to your RFC, and they're going to say, are you still able to do that work, the past work that you did? If the answer is yes, you can still do the past work that you did, then they're not going to find you disabled. Your case will not be approved. If the answer is no, you cannot do your past relevant work because of your medical conditions, then you're going to move on to step 5. Step 5 says, considering the medical vocational factors in the case, can the claimant make an adjustment to other work that exists in significant numbers in the national economy? So if you can't do your past work, can you do any other work in the economy? So they're looking at your RFC and your other medical vocational factors. That's things like your age, the skills you have, your highest level of education. Looking at those things, is there any other work you can do in the national economy? So in other words, are there any other jobs that you can do on a sustained basis given your physical and mental limitations? If no, there are not any other jobs you can do on a consistent full-time basis, then you do meet the definition of disability. There will also be vocational experts or vocational witnesses at your hearing, and they're going to testify, and their testimony is going to be important in helping the judge come up with any other jobs in the economy that you may or may not be able to do. So that's really what these are the questions that the judge is asking themselves in the hearing. So finally, I want to just talk about the hearing itself. So who's going to be at the hearing? I just mentioned the vocational expert, but the ALJ, the administrative law judge, you are going to be there. You're the main witness. There's going to be a hearing reporter there who's typing and taking notes to record what's happening in the hearing for the purposes of keeping a record in case there needs to be an appeal. And again, most hearings will have that vocational expert. The vocational expert usually these days appears by phone. The vocational expert, like I said before, plays a role at step 4 and step 5 in determining your past relevant work and if there are any other jobs in the economy that you can do based on a series of questions that the judge and you or your attorney is going to ask the vocational expert. Sometimes hearings will also have medical experts. That seems to be relatively rare, at least in the cases that we see, and at least in this state. Um, you should know that these hearings are completely confidential. Besides the people in the room when the hearing is happening, no one is going to be hearing it. Nobody is going to be able to disclose what happened in the hearing without your consent. Um, so at the hearing, you're going to provide testimony to the administrative law judge, and you're going to do this by answering the judge's questions or your representative's questions. Um, or if you don't have a rep, you'll be given a chance to tell the judge why you are there at the hearing, why you think you're disabled, and why you can't work on a consistent full-time basis. You're going to talk about what medical impairments you have, and how they affect your day-to-day life. You're going to go through your work history, your educational history, your current functional limitations, and the things you do in your day-to-day life that might relate to work-related abilities or work-related things that you could or could not do if you had a job. So after that, the judge is going to issue a written decision. It could take many months for you to get the decision. It will come in the mail. And if you are not happy with the decision, if you receive an unfavorable decision, you have appeal rights. Specifically, you can request that the appeals council review the judge's decision for any errors. And I think that's it for today. Let us know if you have any questions about this presentation. And I think you're also going to be getting a survey. So if you can fill that survey out, that would be great. And specifically, I think the survey has a question about future Social Security or SSI topics you might be interested to learn about. So you can also mention those in your survey. And that's it.
Awesome. We do have one question at the moment. Again, if you do have a question, you either need to type it in the Q&A box on Zoom or put it in the comment section on Facebook. Someone is asking, how do they file if they have two medical factors? Is it true they can only pick one if they are filing online?
I think by medical factors, I'm assuming you mean medical conditions or medical diagnoses. Um, and you definitely can argue that you have many different medical conditions. So you do not have to pick just one.
That's the best answer to that question as well. For the person asking about this transcript, I was going to say this a little later, but a recording of this presentation will live on our Facebook page for about the next 30 days and then on our YouTube page indefinitely. So you're welcome to save the transcript, or you're welcome. Essentially, the recording of this presentation will be available at any time for you to review in one of those places. Not seeing any other questions at the moment, so just going to give it a second here. Interesting. For the person asking about the transcript, I was not aware that that was an option. I will probably won't be able to save it for this particular session then, since this session is, in progress, but I will look at updating that for future sessions. Regardless, like I said, it will include a copy of the closed captions. You can watch this recording at any time, either on Legal Aid North Carolina's Facebook page or our YouTube page in about a week. Someone's asking, I'm assuming this is at the hearing, can someone else speak for the mentally ill applicant? I think that's what that's asking.
Yeah, so the claimant, the person who's applying for benefits, can certainly bring witnesses to the hearing. And also, again, if that person has an attorney, the attorney or representative also could speak for the claimant.
Gotcha. Okay. Doing one last check here. Again, we're not going to be responding to any specific questions or questions about representation. If you think you may qualify for Legal Aid North Carolina services, you will need to call into our helpline. Our online applications are currently closed, and so our hours for the phone system are different right now. Let me just pull that up really quickly so we have it. Right now, you can reach us by phone at 866-219-5262, Monday through Friday from 8:30 a.m. to 4 o'clock p.m. So again, our online applications are currently down as we are updating our system. All right then, with all that being said, I'm going to go ahead and say thank you to all of you for joining, with a special thank you to Megan for presenting. Again, if you want to review any of this information, it will be immediately available on Legal Aid North Carolina's Facebook page, and then in about a week, it will be available on our YouTube page indefinitely. If you would like to register for one of our other listen and learns, such as child custody, simple divorce, fair housing that begins next week, you can do so on our website at legaladnc.org/clinics. And again, please do respond to the listen and learn feedback survey. I posted a link both in the comment section on Facebook and in our chat here. And for those of you attending on Zoom, you might also get an automatic link once the session ends. Thank you all so much, and I hope everyone has a great rest of their afternoon.
Bye.